Well, good afternoon, everyone, and welcome to the latest in a series of Construction Leadership Council webinars. Today, you are here for COVID-19 Managing Disputes and Costs. If you're not here for this, you may have logged into the wrong webinar, but hopefully we can see that people are flowing in at the moment. So a really interesting subject that we've got some expert speakers on to talk about today. So if we can go to the next slide, please. Yeah, so just by way of introduction, I'm Alistair Reisner. I'm Chief Executive of the Civil Engineering Contractors Association. I'm one of the members of the CLC task force that's been responding to COVID-19 since mid-March this year. If we go to the next slide. So, well, why are we here? Well, unless you've been living under a rock, we are in sort of epoch-making times at the moment. I don't think anyone can realistically say they've experienced anything quite like the impact that COVID-19 has had on the sector. And so one of the very early issues that we noted was likely to emerge was because this was so unprecedented, there wasn't perhaps the contractual mechanisms ready to go in place to address this. So we needed rapidly to move to understand what COVID-19 meant on a contractual and commercial basis. The reason we wanted that is because the very worst thing that could happen to the industry would be a plethora of disputes blowing up across the country, taking attention away from getting on with delivering, getting on with regrowing the economy. So we have helped provide guidance on that, and hope that you've all had a chance to see that guidance on future-proofing contracts, but also developing support on predicting the costs associated with construction COVID-19 and how we assess and report those cost implications. So our speakers today are going to speak about that. This is about all you're going to hear from me, which is probably for the best. So I will just go on, if we go to the next slide, to introduce our speakers. So, as I say, I'm Alistair, and I've done the welcome, but the better part of it is Rob Driscoll, who is Director of Legal and Business at ECA, formerly known as the Electrical Contractors Association, and he'll be talking about how to manage contractual disputes. Helen Stewart, a Senior Associate at Trowers and Hamlins, will talk about record keeping and disputes. And then David Bebb, partner at Fenwick Elliott, will talk about future contracts. We'll then break for a second to raise any Q&A, and I would strongly encourage you to use the chat function to raise any questions that I'm sure you will have during the course of this. Then we'll dive headlong back in with Simon Rawlinson, Head of Strategic Research and Insight at Arcadis, who will talk about managing costs and the excellent work that's been done in this area. So I'm basically going to shut up now and move on to our first speaker, which is Rob Driscoll. Rob.
Thank you, Alistair. Hang on, next slide. So I'm going to set out for you the kind of economic context of what Alistair was describing, which is the cliff edge the economy was facing. This is taken from an OBR, Office of Budgetary Responsibility report, developed at the start of April. On the furthest right-hand side, you can see the depth of what they assume to be the crash of this recession right across the whole of the economy. And if you compare that to the far left, you'll see that it far exceeds what they spotlight as Spanish flu and World War I. So there was a great worry about how the economy as a whole would fall over. If we can go to the next slide. Here, I've just borrowed a couple of diagrams from CBI to also demonstrate where construction sat in the mix of things. So we were one of the lucky economies on the left-hand diagram, the third one down, where you see that actually most of construction stayed open during the pandemic and wasn't locked down. Whether you agree with that morally, economically, it made sense. And as you move to the right-hand diagram, just about the middle there, you see that actually that's done us a favour in terms of our unemployment, where we are one of the lower sectors within the economy. And if you can move on. Now, what we've got at the moment is an economy where construction as a whole tends to suffer a time lag. We enter contracts, we tender for them. The contracts may last for anywhere from 6 to 18 months on average. They may be longer, they may be shorter. And that means it takes a while for any kind of economic impact to crash on us. So we were fortunate enough that when COVID-19 first hit in March, and you saw these OBR reports coming out of the government about what's the size and the shape of the recession would look like, we had some time to quickly get together a group of experts on things like disputes and how these contracts would be impacted and prepare for it. And this is just what you can see throughout the rest of the year is the various government initiatives like the Coronavirus Business Interruptions Loan Scheme, the Coronavirus Job Retention Scheme, and other initiatives will taper off as the economy tries to start to right itself. And on next slide, please. And you just see some of the biggest challenges that face the business community wide across the sectors, and specifically in construction: cash flow difficulties, how are we going to get hold of finance, and other issues. So all these factors tied in together. What we couldn't try to sustain in the industry was mass scale insolvency. There's a lot of media press at the moment about redundancies and how we save the people's jobs, but actually, if you step a stage further back from that, if you can save the businesses, then you can save the jobs. Next slide, please. And part of this was then embedded into the Construction Leadership Council's ongoing strategy, which is how you take us back out of that crash through restart, reset, and reinvent, which was the 3 stages of the 3-year strategy. And on the right, you can see there that very much an integral part of that is to minimise the disruption due to contractual disputes. So that takes us into the substance of what we're here to talk about. Next slide. And so we have, from March onwards, a number of different factors that set out how construction could operate, but it was subject to Public Health England guidance, health and safety requirements generally, evolving site operating procedures, which is where the contractual web starts to get slightly more complex, because you had version 1, 2, 3, 4, and now we're on 5. You had the evolution of COVID safe working guidance. You can see there at the bottom for construction and other outdoor areas, manufacturing, factories and offices, which all affect the construction environment, and the FM and maintenance sectors across infrastructure, homes and everywhere else. And each one of those was trying to outline, okay, if we're going to stay on site, if we're going to continue to deliver contracts, how do we do it in a safe, secure way, in a way which doesn't upset the contractual performance of both sides in a contract. Next slide, please. So that led to this following timeline. We're actually in March 23rd, we had lockdown, but prior to March even, the public sector and the government started to gear up and prepare themselves for the disruption that was to follow. So they have things called public procurement notes. That's where government tells itself how best to conduct its business, because the government isn't one amorphous mass. We think it is, it accounts for 35% of demand in the industry, but in reality, it's thousands of procurement points. So the first one relaxed the procurement rules and allowed people to act quickly, decisively. The second one, which is more poignant, which is PPN 02/20, was the one on supplier relief, and that allowed the government to secure its supply chains in order to prevent supply chain collapse, ensure business continuity and continuity of public services. So if you're working for the public sector, you should have been all right, or at least should have been able to use these documents to your advantage, and may yet still be able to have a sensible conversation with your client in order to reach a collaborative settlement to accommodate the impact of COVID-19 in your contracts. CLC then released its statement on hoping that the industry would do the right thing as far as payment and contracts were concerned. And then governments went even a stage further and translated PPN 02/20 into construction. And that was quite poignant because it started to talk about what measures could be adopted within construction contracts, how they could accommodate the impact of COVID-19. And it even gave templates so that you could settle the contract. And then on May 7th, Cabinet Office, in an unprecedented step, stepped forward and said, these are our expectations of all business as to how they would behave responsibly in respect to contracts impacted by COVID-19. Equally on the same date, thanks to the CLC working group, industry responded in like by issuing guidance, which is what we're here to talk about, and I'll leave Helen and David to talk to you in more detail about what the substance of that advice looks like. Now, those two pieces of advice, the Cabinet Office guidance note was then extended on the 30th of June, and we also had PPN 04/20, which then transitions us out of the lockdown through the recovery period, as the original PPNs only really lasted till the end of June. This is an evolutionary process, you can see there. And most recently, on the 14th of July, we also have the most recent guidance from the CLC on future-proofing, on record keeping, and a summary guide to the original more in-depth guidance. So if we can move on. Just explaining what that PPN is, it's a guidance note to the public sector. It covers business continuity. It has a but-for testing. It basically says if the business was viable but for the impact of COVID-19, public sector could look to usurp its usual rules of operating, and that's me paraphrasing, and do all sorts of new things. But it would require the contractor to have an open book understanding with the client. It would require it to pay a supply chain within 30 days as per the public contracts regs. They could adjust KPIs, they could have shorter payment periods, they could issue extensions of time, postponing LADs, they could do advance payments, they could release retentions. There was all sorts of flexibility built into that. And these are conversations that haven't just gone by, they can still be had with clients. If you move on. So the Cabinet Office guidance note, that's the one I spoke of earlier. It refers to all of commerce, so it covers public and private. It doesn't cover the devolved administration because procurement is a devolved policy area in which Scotland, Northern Ireland, Wales would do their own thing, but you may well find they've adopted similar guidance in some form or another, or perhaps in Northern Ireland's case, they may well have adopted it wholesale. It lasted until the end of June, but as I said, it was then extended. It complements existing arrangements, so it didn't try to usurp anything that was already there. But what it did, and you can see from the right there, from the quote, is it expected people to have just and equitable contractual outcomes having regard to the impact of on the other party and the contractual performance. But it would include the availability of financial resources, protection of the public interest, and health and safety. It was the call to arms by the government, just as they'd asked people in their individual lives to stay at home and stay safe. And it was trying to ensure cash flow, wages, and supply chains within the economy were kept somehow safe and secure, and we avoided whole-scale dispute situations. Next slide, please. In terms of what it went into, in terms of the depth, it covered the scope of the contract, delivery, impaired performance. It could cover the changes to payment mechanisms, as well as time to cater for the disruption and/or costs which were incurred as a result of the disruption. Or it might even mean that things needed to be suspended. And it also asked them to look at third-party agreements, such as bonds, guarantees, and make sure insolvencies didn't just call in the guarantees where it wasn't quite needed yet. So it was, as I say, it was a call to arms to avoid those disputes and enforcement mechanisms being automatic. Next slide, please. Excuse me. Moving into the SME guide. So in the context of all this, CLC released its guidance, managing disputes within coronavirus. The summary guidance has now been released. It has 4 key steps to it. The first is to establish concurrent conversations, reality test your position and optimize your position. There's no point in starting a fight that you cannot win because you do not have the resources or evidence to back yourself up. And then realistically offsetting the time and monetary costs of aggressive adversarial entrenched behaviour against the benefits of collaboration. You've heard me use the word collaboration all through my section, and it's a reoccurring theme of where we're trying to get to. And then lastly, use the formal resources available at your through the website and the links on it. Next slide, please. So establishing concurrent conversations was about two things. People often think you only go have a fight or you have negotiations. You needn't. You may have two conversations at the same time. One is where you continue to operate your contract, do the right things, operate them, all the clauses, whether it be NEC, JCT or some other form. And the other is where you say, okay, we'd like to have an off-the-record conversation. We want it to be two phrases that the guidance picks up without prejudice and subject to contract. The legal phrases that are designed to create a safe space in which you can have that off-the-record conversation, kick the tires or kick the ball around, whichever analogy you want to use, and offer information and potential solutions in order to achieve a settlement. If it doesn't work, you're still operating the contract on both sides of the fence. If it does work, it takes you a long way down the road through collaborative behaviour rather than entrenched aggressive behaviour. Next slide, please. So in terms of reality testing yourself, there is a checklist in the summary guide. I'm not going to do the spoiler here because Helen can take you through the importance of this area of record keeping and which sits behind the checklist in many ways. But what all it's trying to do is get people to reality check their own positions, because everybody thinks they're right when they go into an argument. But in actual fact, the process of good legal advisors is not just to manage the disputes and look after their clients' interests, it's also to strengthen their position and actually ask them questions about, well, where's the contract? What's it made up of? Is it emails? Is it documents? Gathering the information, having an honest exchange, variations, where did they happen? How did they happen? What's the impact on our time program versus the entire project? Asking yourself that whole series of questions can take you a long way to defining what your position is, what your chances of success are in evaluating the other parties too, alongside that other dialogue, which is actually, why am I here when I could be striking a deal, having that deal recognised and carrying on with a successful project delivery and helping my own business to survive. Next slide, please. So in terms of disputes, I think it's also worth mentioning that the guidance has this table in it. It just lines up the dispute systems in comparison, because in my experience in the industry of nearly 20 years, everybody's got a slightly misaligned view of how long these things take, how much they take. Usually those views are vastly underestimated. For large sum disputes, litigation or arbitration may be worth it. But if you need money now due to cash flow reasons, or you don't want your business severely tied up in managing and resourcing dispute resolution systems when you would be better making money on jobs and projects, then it may well be worth reaching that collaborative deal. Adjudication may be fast, but inevitably it involves solicitors and sometimes barristers. I work a lot at subcontract level where arbitration is never really worth it because of the cost and time involved. Mediation, as a mediator, it's always successful, even if it's just to create a common understanding whether people reach a deal or not. But they are now much more flexible systems within the industry to help you guys, even if you need a little bit of outside assistance, reach that common understanding and record it in some way. Next slide, please. And then lastly, I said there were some resources. So I alluded to them earlier. If you go down the list that's in the guidance, the PPNs are there. The templates are either in PPNs for reaching a deal, recording that deal in writing in a binding way. The original full guidance also gave you some pretty expert, easy to adapt letters and templates for JCT and NEC style contracts, geared towards the main contract version, but very easily adapted for other versions, which can be used to create that collaborative dialogue that we spoke of earlier. So as I said, it's a four-stage process of establishing the two concurrent conversations and not viewing them as exclusively one or the other. Testing your own position to make sure you are as strong as you think you are, and making sure that you can have all the information to hand to have that honest, open dialogue. And then thirdly, measuring up the fact that you may well find that because of COVID, your business is in a pretty tough predicament where no outcome is particularly pleasant, but actually the collaborative one lines up as being much more affordable, efficient, and best for your business over an entrenched, aggressive adversarial position. And then lastly, how to seal the deal and put it in writing in a binding way. So I think Helen's going to take you on from here and talk to you about the importance of that in backing up your position in order to navigate the disputes territory. Helen, over to you.
Thanks, Rob. So as Rob said, I'm going to build on what Rob's just been discussing there. I helped draft the contractual best practice guidance, which looked at managing contracts and also avoiding disputes, and also the record keeping guidance. If you could move on to the next slide, please, Omar. So just dealing with the record keeping guidance first. This was the later guidance that we produced, but it was a topic that came up when I was asking those at the coalface what would be most helpful and practical in terms of looking at claims related to COVID-19. We have drafted it for that purpose, but I would say it is of general application, so it would be useful in respect of any type of claim, I would have hoped. And it's a subject that as a disputes lawyer we discuss frequently with clients because it often becomes an issue when we're looking at claims retrospectively. So why is it important to keep good records? We touch on this in the guidance. One of the most immediate benefits, if you are discussing issues in meetings, in emails, if you're having these conversations with the other party at the time, it gives you that opportunity to work together to try and resolve issues. So if you don't discuss or record the issues that you're having, you're potentially losing that opportunity to work collaboratively, as Rob discussed earlier, to try and minimise the impact of delays and additional costs at the time. For example, if during the recent times you've had problems with materials and a material is specified in the contract,
it's problematic.
And in obtaining that material has been delayed due to lockdown, you know, you might discuss with the client changing that material to one that you can freely get, and the client might not have a problem with that, and it might mitigate their losses in terms of delays to their project, if you're entitled to an extension of time where they wouldn't be getting the LDs from you. Good records can make or break a claim. So if you have a good claim, you know, if you can't resolve that with the other party, you know, if you want to take that forward, you will have to prove it in one of those dispute resolution methods that Rob had in his table in terms of adjudication, litigation or arbitration. You have to prove it on the balance of probabilities. So if you don't have the records to show your claim, especially in court or arbitration proceedings, you're unlikely to be successful. And I suppose following on from Rob's discussion in terms of trying to resolve claims, if you have good records and you can put your claim across to the client in a robust and a way that's easy to follow, it's going to be a lot easier and quicker for the client to be able to agree some or all of your claim through negotiation. And they're then going to be unlikely, they'll also be unlikely to want to incur the cost of trying to dispute it if you've got those good records and a good robust claim. Whereas if it's unsubstantiated, you're making it more difficult essentially for your client or your employer to agree it. So what we did, we've put together some high-level guidance on why it's important, what type of records you should try and keep, and how you should try and keep them. It's not detailed guidance on delay and disruption or loss and expense claims. Sorry. But the SCL, so the Society for Construction Law, they do have detailed guidance by way of the delay and disruption protocol that we reference in the guidance, and that's free on their website. And that has very detailed guidance on that. It's around 80 pages, where ours is around 4. So please do look at that for more detailed guidance, as that's very helpful. As Rob said before, in terms of having those concurrent collaborative discussions with the client, record keeping is something that should be done at the same time as having those collaborative discussions, and at the same time as fulfilling your contract administration obligations. So some of the records that we talk about are likely to fall under that contract administration and requirements, but some of them are additional. And it's important to be doing that at the same time and keeping contemporaneous records while the project is progressing. We do make the point in the guidance that record keeping should be proportionate. We do list a lot of different types of records in the guidance, but for smaller, simpler products, you probably don't need to keep all the types of documents referred to, and the resources that it might require to keep all those types of documents could be disproportionate to your claim or the value of the project as a whole. There's a lot of emphasis on contractors keeping good records, but employers should also keep good records. They may not agree with a contractor's version of events. I think Clerk of Works kind of went out of fashion a little bit with D&B contracting, but on a lot of projects that I've worked for, it's always been most helpful if an employer has its own set of records, almost like an independent set of records, if you like, to counter any version of events that it doesn't agree with. We make the point in the guidance that it's always good to try and agree the type of records to be kept. Many contracts don't have detailed provisions on what records should be kept, so you can try and agree that at any point during the project, and it would always be best practice to try and do that. You won't always be able to agree, but it's worthwhile trying to do that. Try and avoid what we call global claims, which is what we see a lot. And these are basically claims which don't forensically prove a causal link between the impact on the project, so the costs or delay, and the risk event being claimed. So here, COVID-related risk events, because you have to have that. You have to prove your claim on the balance of profitabilities, and you have to link those two elements together. So if you can move on to the next slide, please. Thank you. So, as mentioned before, contemporaneous records are always the best evidence when looking back at a claim. So, as well as trying to agree the records that you keep, it's also good to share them, share things like progress records as you go along in the project. If you don't agree with the details in the records, in meeting minutes, in emails, etc., that are being shared, go back on it, because if you don't do that, it'll look odd later on when we're going back and you're disputing that version of events, but at the time you didn't dispute it in the meeting minutes, in emails, etc. The goal is to be able to clearly evidence the effect or projected likely effect of COVID on the project relative to your entitlement under the contract, i.e. a claim for an extension of time or loss and expense, or both. To do this, you'll need to show how the works were planned to be undertaken as against how they now need to be undertaken as a result of the risk event, as well as mitigation measures considered and or implemented. And that's because under most forms of contract, there are obligations under the contract for contractors to mitigate any delays, however they've been caused. So it's always good to have evidence of how you've sought to do that as well. So in terms of the planned way of carrying out works Hopefully that can be shown by the original contract or tender programme, the planned resources, and a detailed breakdown of the contract sum. And then in terms of looking at how that has changed and the type of records to be kept, the guidance lists out various types, and I'll just pick up a few points here. The programme is a key document and it should be updated in accordance with the contract, but even if there's no obligation to update it, you should do so just to record the actual progress and any disrupted or delayed activities. And you can also issue it for agreement. Again, if you've got that sharing of information, if the other side don't come back and dispute things, then that can be helpful later on in a claim. Progress records, so reports showing progress made, labour activities, plants, materials, plants and equipment on site. And there's a lot of people obviously now using more and more technology in terms of videos and drones and time lapses, photos, and we've even heard of technology at the moment being used to track operatives to ensure that social distancing is being maintained. So there may be potential to use that kind of data that's being picked up there in claims. Always to make sure that the contract administration is being kept up to date and that you've kept good records, that you've complied with the contract. For example, in terms of instructions, in terms of notifying the delays, as Rob mentioned earlier, we've given pro formas that can be adapted to your project in terms of notifying delays under the JCT and the NEC form of contract. If verbal instructions are given, always try and confirm them back in writing so you've got that record to show it. Cost records, so direct costs, labour, plant, materials, etc., but also indirect costs in terms of trying to evidence your overheads, lost profit in terms of turning away works and finance charges, etc. And we briefly touch on how to keep your records, and that is digitally. I think most people do that now, and there's a lot of technology and storage systems and protocols that can be used so that you can quickly and efficiently find and pull together records. If you're on the receiving end of an adjudication in that unfortunate position, you have very short timescales in which to respond. So you do need to be able to pull all these things together very rapidly, and you also need to bear in mind issues associated with people if they're on furlough or part-time furlough. You know, if Joe Bloggs has only stored everything on his laptop and he's on furlough, it's going to be more difficult to try and get those records back. Try and link the records together as you progress, so linking progress records with updated programs and cost reports with a short, simple narrative. That'll be really helpful when it comes to putting the information across to the client or the employer, or later down the line making a claim if you need to. If you can move on to the next slide now, Emma. So proactively try and avoid disputes. Some contracts are more suited to having discussions about risk contemporaneously, such as NEC and alliancing contracts. Others are not so structured. As Rob referred to earlier, you can have conversations on a without prejudice and subject to contract basis if you're trying to reach a settlement, so you can be open and frank in your discussions, and they can't then be referred to later in any formal dispute proceedings. And as Rob also mentioned, we've given the tools in the initial guidance to start the conversations, start those kind of without prejudice conversations, as well as also complying with the contract administration requirements. What we see frequently is, especially when works are ongoing, but maybe at a reduced productivity, is that claims tend to be, I mean, people will notify the claims and they'll notify, you know, how much time or money they think that they're entitled to, but people don't really get into the nitty-gritty of them until the end of the project, and I do think that is storing up trouble for later. And whilst I appreciate it's natural not to want to have these difficult conversations, as we've said earlier, it can help mitigate the delays that are ongoing. But it's better to try and resolve these things when they're fresh in everyone's mind, when you have the same people on the project. And when it's not entangled in other issues that might have arisen subsequently, that can create more of a gulf between the parties when they're all stored up, and create a bigger, I suppose, gulf between the parties at the end. As Rob stated earlier, your entitlement depends on your contract, and that's the starting point that you need to establish. So whether you can get an extension of time or loss and expense depends on checking the contractual terms and applying them to what has happened on site, and making sure you've followed the contract administration requirements in terms of notifying that delay. Obviously you can have time bars if you haven't notified delay under contracts like the NEC. And then once you've established your entitlement, then you need to establish the extent of your claim using your records. Take advice if you're not sure on your position, so that you can go into negotiations and conversations with the other party and be fully informed of what your own position is. But also try and get both parties to consider the wider commercial position. So there's a lot of points we made in the initial guidance as things that might be relevant to try and discuss in terms of costs that are not covered by the contract, costs that both parties would incur, if they were going to go all the way into a formal dispute, that can be brought into the mix, I suppose, in addition to the strict contractual position, to try and reach a more commercial settlement. Before reaching any resolution, you'll need to consider any of the third-party buy-in you might need up or down the chain. So, for example, employers might need the agreement of purchasers or tenants or their funder, and contractors might want to get subcontractors on board before they reach an agreement with the employer. And then, as Rob touched on earlier, to fully record any agreement reached, you might need to enter into a formal settlement agreement to make sure that everything is covered and to give certainty to the parties going forward. If you can just go on to the next slide, Omar, please. So we can all be optimistic and hope that all claims can be resolved, but I'd be without a job if they could be. So not all negotiations will result in settlement. All projects, circumstances, issues and personalities, which can play a big part, are all different. And even with the best one in the world, some claims you might not be able to resolve. But if you have kept good records and you properly understand your entitlement, you will be in a good position going forward. The point is that you need to be conscious, as Rob said, that the more formal ways of trying to resolve a dispute will take time, resources and potentially costs, so legal costs, adjudicators costs, court fees. And one of the main things that I see clients overlook is the amount of resource that it can take to pursue disputes. So they can be really resource heavy, especially when you don't have dedicated people working on disputes. So everyone's trying to do their day job whilst trying to push through the dispute at the same time. And again, you might have less resources if people are on furlough. In terms of the best method to try and resolve disputes, again, the first place to start is checking the contract. Most contracts have dispute resolution provisions that you would have to follow. Most construction contracts have the right to adjudicate under statute, even if that's not expressly stated in the contract, but there are exceptions to that, such as supply contracts and some weird exceptions about works on particular sites. And the contract might provide either for court or arbitration as a final means of resolving disputes. Some helpfully have escalation clauses, and they can be useful to take disputes to more senior people that haven't been involved in the project and so potentially are not so entrenched or taking things personally, and that can help make breakthroughs on disputes. And then in terms of mediation, adjudication or other ADR, litigation, arbitration, Rob's earlier slide had a helpful table, which is in the summary guidance document, which outlines the pros and cons of each one. I think one thing to bear in mind is that negotiation can be done at any time. So even if you have taken your dispute to adjudication or litigation, you know, the negotiations can be an ongoing process, and you can pick them up at any point in the process. And that's the point I think people tend to forget a little bit as well. Just finally, there's reference in the guidance to the RICS conflict avoidance pledge, and that is a pledge to work that companies make to work proactively to avoid conflicts and resolve disputes at early stages. And so companies sign up to it, and they get published on the RICS website, which also has a toolkit if you as to how to use it. I mention it as well because it is quite aligned with our guidance, and in terms of proactively trying to avoid conflict and having collaborative discussions as early on as you can to try and resolve disputes. And I suppose going forward on future contracts, you can check whether the other parties signed up. It might make a difference to who you want to work with going forward. And so in terms of future projects and contracts, we're going to move on now to David, looking at the future proofing guidance.
Okay, thank you, Helen. Thank you, Rob. So my name's Dave Bebb. I'm a partner at Bennick Elliott. Unlike Helen, I spend most of my time looking at contracts going forwards rather than sorting out the problems in current contracts. I think Helen and Rob both made the point that if you're unfortunate enough to get involved in a dispute, it will sap every last bit of energy you have, and often may sap every last pound you have. And the one dead cert is you'll never work for that client again. If you could just flip my slide for me, please, Omar. So I tend to spend my life looking at jobs going forwards. But I think the most important thing, and Rob and Helen have made this always, I think before I look at the CLC amendments as to what you might think about in contracts going forwards, we just have to reinforce some of the basics again, which Rob and Helen have touched on, which is this. And I've been doing this 20 years now, and I was always taught, you know, if there's a problem, it's all about the contract, and then second, it's all about the records that support what you did when you were operating that contract. And if you can't tick those two boxes, you are a little bit on the back foot. Now, I think it's safe to say, isn't it, at the beginning of lockdown, what's that, 4 months ago, I think there were more contracts sort of located at the back of fridges on site offices or propping up door opens in porter cabins, and they were dusted off simultaneously to work out who took the risk of COVID-19. And there's a reason that's important, again, because it's all about contract. Because if you look at my little second bullet point there, more or less what English law says is you can divvy up the risk any which way you want. You can put it all one side of the fence, you can put it all the other side of the fence, or you can meet somewhere in the middle. It also assumes that you've completely understood what you've signed. When you put your paw print on a document, it is a very disappointing contractor employer who comes back to court and then later says, well, it's not what I thought I signed, or it's not supposed to mean that. You will get very little sympathy from an English court. So again, what I want to reinforce is how important this is in terms of divvying up the risks. Just my third bullet point there, just for contractors who are listening, I think it's probably fair to say as well that as a default position, an awful lot of risk sits at a contractor's doorstep, particularly on lump sum contracts, unless the contract says it sits at someone else's doorstep. So that's what a lot of contractors, I think, found when COVID-19 kicked off, is that they were looking, well, where is the relief for this job just being really, really difficult and me not being able to get the right labour and the materials? Where's the bit of the contract that gets me out of jail? And we've had the discussion, of course, that does it amount to a force majeure under JCT? Yes, it may not, but it's these little things that you're looking for in the contract to give you effectively the get out of jail card that I think probably it's fair to say that as a contractor it would typically sit at your doorstep. I think just on to my fourth bullet point there, it's very important as well just to bear in mind that when we look at these contracts, every job throws up something specific to itself. There is no two jobs the same. You know, I've got projects now in city centre locations that ironically sometimes can be easier to carry out because we've got no traffic, we have no tenants in the building, we can work the hours we want, and we can get in the lift. Similarly, we have projects out of town on a greenfield site that can carry on. So it's very much looking at the particular job and thinking, where is the risk in this particular job? And that's the point I want to sort of reinforce here. You have to think, unfortunately, like my lawyer thinks, or my wife thinks, I was born with my glass half empty. Because my job, I suppose, is to look at that project and sit down with either my employer client or my contractor and sort of say to them, well, where could the wheels fall off? And the point is, they will say, well, how long have you got, Dave? Here's the top 10 things. And of course, that information already exists. We have risk registers. We know where the risk in the job is. The point is, it doesn't always marry up in the contract. I've lost track of the number of contracts I've looked at that just say different things in different parts. If you ask a lawyer where they spend their time unraveling the mess, they will say, well, I've got this bit of the contract that was done by a fellow called Dave, and this deals with the legal bits. And then I've got a document in the back that's a post-it or an email, and that says something completely different. Oh, and I've just found an exclusion to the price, and that's something different completely. So you end up in all these different things in the pie pulling together this contract, but the risk of things just saying different things is huge in practice. So it's really important that you sort of sit down there and think, right, where could it go wrong? And then turn to the relevant clause that says, if this happens, this is actually how the contract deals with it. And if you can't find how the contract deals with it, effectively see my third bullet point if you're a contractor. So my penultimate bullet point there, as I've said, contracts have typically included assumptions and exclusions to the price, and it's no different now. COVID-19 has got the same, it brings up the same issues. At the beginning of the job, you can sit down and say, well, will this job be more difficult? Will it be easier? What is likely to happen? I think just some of the examples there, we know that projects now are affected by the safe operating procedures. And I think that's the one thing as well where there's an element of certainty to that. So even if there might be no certainty in terms of things like lead time for materials or a second wave, I think generally now the industry is pretty clear that if we plug in the safe operating procedures, this has an effect of X on the program and Y on the price. So I think what I've seen over the last few months is that particularly contractors now are quite adept at saying this project that would have been 20 weeks were it not for COVID-19, that is now 25 weeks, and this is how we can show it's 25 weeks. So that's the one sort of certainty, I think, where there's a bit more clarity over what the effect of some of the unknowns are. Okay, so just at my final bullet point there, what the CLC template amendments do, they're really good at setting out a general starting position for how we deal with COVID-19. I've spent the last 4 months looking at hundreds of different examples as to how someone describes COVID-19, how someone describes a pandemic or an epidemic. And what this does, of course, is do away with all that. We have a definition of what a pandemic is, and we have some very simple provisions that I'll come on to that deal with what happens if the position gets worse. It just saves reinventing the wheel every time, because as I've said, the amount of amendments I've looked at over the last few months, they all start in a different place and they're all very specific to whichever lawyer happened to have drafted them. What these do is give you an excellent starting point to deal with it. But of course, as I say in the last bit there, again, if you follow my sort of process through of thinking about the specifics of your project, you may well need to take them as a starting point and then just sort of build on them afterwards. Okay, could you just flick to my next slide, please, for me, Omar? So what do they do? Well, as I've said before, we have a new definition of a pandemic event, which is a good starting point because, as I've said, for the last 4 months, I've argued with probably most lawyers in the country as to what COVID-19 means, what it doesn't mean, and how we deal with it. And then what it says, so it's quite widely written, which is useful, of course. It includes any pandemic, also includes variants to it. So there was something even last week on the radio that already the scientists are coming up with different strains of COVID-19. And I suppose, again, from a drafting point of view, if you put 2 lawyers in a room with 2 scientists on their side and said, is this COVID-19? You may well get 2 different answers. One will say, yes, it is. One will say, oh, it's a slightly different strain of it, and therefore doesn't quite fit within the contract definition. So it deals with the fact that it's a sort of bit of a moving feast. It deals also with generally with the sort of the measures and the recommendations that as a contractor you would need to follow. So there's been all sorts of debate over the last few months about, is it a change in law or not? Is a safe operating procedure a change in law? Well, it sort of does away with that because it says, well, whatever the contractor or the employer have to do to deal with it, is whether that is a legal effect or not, it's caught within it, okay? And then the only sort of last test is obviously the consequences need to be outside the control of the contractor. So we know that access to site is an issue, but again, every job throws up different issues. I've got fit out in the city now that once you get to the 40th floor of the building, it's fine to work, but if you can only get 2 people in the lift rather than 20, access is the issue, yeah, because they turn up to work at 10:30 rather than 8:30 and say it was the lift. So again, it's really important just to think about how that affects that particular project. So how does it deal with it then? So my third bullet point, it's beautifully simple. If we can slot within the definition of a pandemic event, we can have the time. So as a contractor, I will have an extension of time, please. It is a brand new event in my list of extensions of time, and it will give me the time. Just bear in mind my original point as to, well, a time based on what? Because at the moment, of course, I think contractors have got a fairly good grasp of what time is to take into account the current social distancing provisions and the SOPs. So it's already, I'd imagine, in reality, is that time is built into what we know at the moment. So my fit out program that would have been 20 weeks, now 25, that is factored in there. So just bear in mind what I'm trying to show is things have got worse than what I'd already allowed for. Second option, I can have time and all the money. So again, contractors having gone from a 25-week program out to a 30-week program, because whatever happened, whether it's a second wave or material shortage or whatever it might be, they can claim the associated costs with that as well. And then finally, there's the third option, which allows you to grant the contractor the time and effectively cut a deal on the money, whether that is a percentage or whatever it may be, and it's just left in square brackets in the drafting as to what that would be. And that's, again, a beautifully simple and short way of dealing with it. Now, again, my fourth bullet point, I've already mentioned the fact that actually some of the COVID-19 things, of course, will already be known about. So the point is, how do we show it's actually got worse? And again, it's back to both Helen and Rob's point is, well, you need to show how you planned to build the job. Well, I can say that, you know, my 25-week program, that would have been 20, but for COVID-19, that assumed I put the welfare here, the canteen was this big, and ABC, and so the list goes on. It's be able to show how I either needed a second canteen or a second drying room, whatever it might be. That's the change I'm measuring, okay? Penultimate bullet point, again, just to reinforce what Helen said, and Rob, it's all very well having these contracts in place. So again, if you look at reasons why things go wrong, well, not understanding the contract is right at the top of the list, and pretty high at the top of the list is just not following it. Okay, so again, we're sort of at the process now where if notices haven't been served for COVID-19, we're probably getting towards the end of the period of where it really should have been, and for some of them you will be outside the time zones. But going forwards as well, still needs to do it. This is not an excuse to take your eye off the ball and to return the contract with these amendments back to the Porter Cabinet it came from. It is still a document that needs to be operated and used throughout the job, and nothing has changed because of these CLC amendments. The final thing it allows either party to do is to terminate where the job has effectively gone on hold for a prolonged period of time. Those of you who do a lot of JCT will be familiar, there's already a provision in the contract that says if nothing's happened for, I think the default is 3 months, but you can write in what you wish, either party can walk away from the job. All I would say, I suppose, again, thinking about the particulars of your project, if you have agreed that the option for the contractor is the time and all the money, is it right that the contractor then has the right to walk away, effectively leaving the employer with a half-finished building? Probably not, so it would need a bit more thought and a few more tweaks to how you deal with it. Could you just flick to the next slide, please, for me, Omar? Okay, so having looked at what the CLC amendments do, what I thought it would be useful just to share the sort of things that I've seen come across on jobs in the last sort of 4 months, and they just happen to be the jobs I've been involved in. I'm sure everyone listening has their own projects that have thrown up their own issues, and by all means share them in the question box as the sort of things that you've come across. These are just some of the examples that I've seen happen on projects in the last 4 months as to how we deal with things going forwards. Helen touched on it earlier, this ability to change the spec. So generally speaking, the contractor cannot change the spec. If that's product X is required, then product X it is. Of course, typically you may say, well, you can have product X or similar approved. Well, what I'm seeing doing now is to avoid the risks is why not go through the approval process now to avoid the delay later on in the job. So if we can have a couple of alternatives pre-approved and give the contractor the flexibility to swap them out, again, it will mitigate some of the delay to the job potentially. What I've also seen, again, on some projects as well, is recognizing that there are certain risks to the supply chain. Can we actually get the job PC'd without some of the work having been done? So I was thinking particularly, I had a project that had some rather expensive Italian joinery in it that there was a very great risk it would be remaining in North Italy rather than being in London where it should have been. So there's no reason why, as a matter of contract, remember my point about the parties are free to agree whatever they wish in a contract. And if you want to agree that actually we will consider this job PC, even though the joinery is not there and the joinery will be fitted afterwards, you can agree that. What that allows to do, of course, it allows the contractor to get PC, it allows the building to be used. You just have to have some thought as to what the temporary measures might be to allow you to use the building. So I've had a couple of contracts where we've said, well, there'll be temporary light fittings or whatever it might be, or temporary partitions while we wait for this stuff that we've identified as a risk, and we will fit that after PC. And it just deals with the sort of issues that in practice often happened on some projects anyway. All we're doing is having a bit more certainty around what the contractor can and cannot do, just to avoid, as Helen's touched on before, this all being dealt with a day before PC, where we say, yes, I'm very sorry, the joinery is not turned up, but okay. Third bullet point there, deferring the start of the job. It's over my last sort of 20 years of doing this, when you sign the contract, it could be a good few months before you plan to start, and it's something that never really had very much attention before now, is that obviously both the employer and the contractor are aligned along the basis of, well, the sooner you can start, generally the better. As long as the contractor's got whatever notice period they need to do, both parties are looking for the same thing. And of course, what we're having now is we could be signing a contract now that may not start, for example, say until November. Well, what happens if there's a second wave between now and November? What happens to that start date? Bear in mind, as a contractor, certainly under JCT, it's the start date, or the date of possession they call it. That's what triggers the clock ticking. So if the clock is started in the middle of a second wave, what happens? So on a couple of projects, I've seen effectively the ability to defer the start date. Well, of course, that works both ways. It won't always work in the contractor's interests, because they will be saying, well, I priced it at early 2020 prices, and how long are you able to defer it for, employer, before you start looking at, well, I can't hold the price any longer. Clearly, you cannot, or usually you cannot simply state that the contractor starts when the contractor wishes to start, and likewise, neither can you say that the employer will dictate to the contractor when they start, if there's this whole risk of the second wave thing. So what we've seen sometimes is sort of a checklist around what needs to be in place before the contractor would start. So you effectively agree what the triggers are for starting the project. And again, all sorts of things will affect that depending on your job, but we've seen things along the lines of certain suppliers confirming that the lead times are now more set in stone than they were before. And you can agree anything, whatever particular is to that project, just have a think about what might happen between now and the start date. Whereas pre-COVID-19, it probably wouldn't have even come on your radar. Next bullet point, the ability of the contractors to pull off site. Again, I've only had this on one project, but I had a project where my contractor client was doing some work to the common parts in a few offices. And it wasn't time critical so far to the employer because the building was still operational. All the tenants could come in and out and it was all working. But the deal done on COVID-19 was, well, the contractor would get the time and not the money. Well, if the contractor can only get 70 people on site, but they really need 150 because of social distancing or whatever it might be, the prelims burn is very much the same. Okay, so should the contractor be able to determine whether work actually stops because it's totally inefficient for him to carry on working? Again, I've only had it on one project, but actually we got to a deal on that. We got to a deal where the employer was happy that because it wasn't paying the extended prelims, the contractor could control at a certain extent whether it was efficient to carry on the work or not. And again, subject to a long stop date and subject to a number of things that would effectively mean the contractor simply couldn't start as and when they choose. The thing that's really interesting that's cropped up is whether there's some change to the building regs on the horizon. So the way typically, certainly JST works, is that there is a provision in there that says if the law changes and it actually requires changes to the work after you start, or after the base date, I think is the terminology, does the contractor get the corresponding variation? Now, as far as I'm aware, there aren't things on the horizon. This is unlikely to affect sort of the smaller jobs, but on the longer term jobs, just think about whether actually there's something on the horizon that may affect the actual work itself. And you could be thinking of all sorts of things in terms of the layout of buildings. There's a lot of talk around air conditioning and air change and air filtering, access, so things like automatic doors to avoid contact with door handles, all this sort of talk out there as to how things may change, or actually best practice for designing offices going forwards. They're not building regs yet, but it's just something that's cropped up on a couple of projects that I've been involved in terms of just a sort of general discussion around, well, what happens if, okay? Advanced payments, Helen touched on it earlier. Typically, if a main contractor phones a supplier and says, well, what's the current lead time? It would often be met with a sort of shrug of the shoulders, your guess is as good as mine, Gov. Nothing better, is there, than getting your order to the top of a delivery list and to oil the wheels with some payment. And what I found a number of projects, as advance payments are made up the chain, if that flows down the supply chain, there is no better way than getting some security on your delivery dates for various materials. Again, putting my lawyer hat on, think about all the issues that throws up, you know, paying for work before it's turned up on my site. I've got insolvency risk, I've got the risk of materials being loaded up onto site before they're needed, so the theft issue and insurance issues, just something to think about. But I've seen that on a number of projects where effectively to secure lead times, you just buy it up front as best you can and pay for it, which of course again isn't always a very good way for securing what you need. I touched earlier on the CLC wording that allows either party to terminate following a prolonged suspension. What I'm seeing is, yes, that is still in there, so there is the provision to terminate either way. What I'm seeing just as often is actually, well, rather than the contractor effectively leaving the employer high and dry with a half-finished building, actually what the contractor is really interested in is just don't hold me to prices that I quoted at the back end of 2019, 2020, when I'm probably, and let's face it, if we have a really rough winter on this, could we find that some of the jobs aren't really getting up and running again until maybe January if there's a whole second wave? So you could be 18 months, 2 years out with some of the prices. Just something to bear in mind that actually I've seen that on a couple of provisions. I think finally my last bullet point really is I encourage everyone just to think, if only for a little bit, like a lawyer, as to you know, with your glass half empty, where could it go wrong? Really think about it practically. This is what might affect this particular job, and then turn to that bit of the contract and says, how does it deal with it? How does it deal with it? Because if it doesn't, then you're into the situation of the points that Helen and Rob have already talked about. Could you just nip to my next slide, please, for me, Omar? Finally, just when slotting in these amendments, the law of unintended consequences. As soon as you dabble with one clause, typically it might affect 3 or 4 others. Now, the way the CLC ones are drafted is they are designed to slot into an unamended contract. I'm sure there are plenty of contractors out there that would say, probably quite rightly, well, when was the last time you saw one of those, Dave? So it's very important that when you do slot in those amendments, you just sit down and think if it doesn't have an adverse impact on something else, because again, you know, right at the top of the list of where things go wrong on jobs is bits of contracts conflicting and saying different things. Just my second bullet point, they are designed, they won't work with every form of JST and NEC. Again, just think about whether it works for the particular form you are using. JST and NEC obviously use the same terminology, and a lot of the time it's the same clause numbering, but not exactly. So just think about whether you need to tweak it for the particular ones you are using. Finally, Helen touched on the point as well about whether you can actually use these as a basis to re-baseline the project going forward. So you may now be in the middle of a project that is 12, 18 months long. If you've agreed a deal on how we deal with things going forwards, there's no reason why these amendments cannot form the basis of something to be slotted into an already existing contract going forwards. Obviously, you need both parties to agree to that, but if you follow Helen's steps in terms of getting everyone to the table and agreeing what the deal is going forward. There's no reason why these cannot be used as a starting point, whether it's to a deed of variation, whatever it might be, but just the way to benchmark things going forward for the remainder of the project. That's probably all I've got to say specifically on how you deal with new projects later on. I'm not sure now, Alistair, do we do the Q&A now? Is it for...
So that was the plan. However, I'm going to apply chair's privilege. We are looking at time. I think it probably is sensible to bring Simon in now, just in case we do run out of time at the end. If we go straight, Simon, are you there?
I certainly am, indeed. So, right. So, thank you, everybody, for taking out the time this afternoon to gather some information about this new initiative, which was launched this time last week. And if I was going to contrast the approach that we're taking to the issues that Helen and David have just outlined, what I thought was very striking about Helen's articulation of particularly the issues around record keeping is that they require a significant level of detail and investment in doing that. So it's fair to say you would only do that if you were thinking that there was going to be a significant problem that was coming up, that you would need to invest effectively in advance of mitigation through some form of dispute resolution. But on the other hand, David was talking about contracts going forward. And if one thinks about contracts going forward, they involve two parties, both the client and the contractor. And in addition to thinking about how the contract might be adapted, they also need to be thinking about how, firstly, the sort of like the business case and the viability estimate might be adjusted for potential impacts of COVID. And of course, the contractor needs to be thinking about that as well. So the issue, and Omar, if we can go on to the next slide, so that the issue that this toolkit sets out to deal with is to create a better understanding at an industry level of the impact of COVID, and emphasize that element. It's about the industry level rather than individual projects and indeed individual elements of projects affected by COVID. And of course, having better cost forecasting means that you have better investment decisions, and that you would like to think that that will result in a more robust pipeline, which in turn creates more workload. So this is very much a recovery-focused initiative. And if I was going to say what the main objectives are to get people thinking about COVID in a consistent way and collecting data in a consistent way, and then communicating those implications to both contractors and clients, again, in a consistent way. So everybody has a broad understanding of what the cost impacts are. So very much contrasting and sort of supporting the same approach that if we deal with disputes in a consistent way, if we deal with thinking about the impacts of COVID in a consistent way, then we'll all become more effective and efficient. If we move on to the next slide. So there are 4 tools. Now, because we're fairly tight on time, I'm actually going to focus on 2 of those. The first one being the productivity measures. So simple methodologies to use information that can actually be obtained from site rather than having to go into lots of other details. So it's information that we know that contractors already captured. And then on the other side, we're going to look at tool 2, which is the estimates adjustment methodology. So that is effectively, again, a consistent way of assisting contractors and particularly consultant quantity surveyors and project managers in communicating adjustments to existing cost plans. So if you'd imagine there was a project that's been in development for the past year or so, suddenly it needs to be adjusted not only for market conditions, but also COVID. That's the methodology. The 2 other elements we're not going to touch very much on, which is a qualification statement and a framework that accompanies that, which would effectively detail the elements that have been included within the qualification and those which are without. So let's say, for example, somebody's being able to do an estimate of the impact of the site operating procedures, but they haven't been able to make an estimate of, say, for example, a future outbreak of COVID that might close down the project. So if we go, I think we can go on 3 slides now, because I think the next one, we just go yeah, if we just hold on. So this one here, this just shows how they all come together. So you've got the data collection tool feeding the information into data analysis, and then that supports the advice. So that's the conceptual framework. And what you'll see there from an overview of the way that the toolkit is developed, there are 2 appendices which have the kits in them. Yep, we can go over 2 slides. So going firstly into the actual, the tool 1, which is the measurement tool. Now, what this describes here is 5 metrics which we use to capture information. Now, you'll see that they are fairly simple. They, again, I'll emphasize they're all at the aggregate level. So rather than, say, for example, trying to track an individual operative and their productivity or an individual piece of plant, we're looking at the overall cash flow or costs of preliminaries, for example. So simply sort of going through those. So firstly, you're looking for planned versus actual revenue. So you're just getting that very early warning in terms of whether projects are being impacted or not. Now, as you can imagine, the contractors will have good sight of that, but actually clients might not necessarily see that because of other information around claims and such like. Workforce indicator, again, a really early indicator in terms of, are we getting as many people on the site as we expected? Is it dropping off? And so that's going beyond so what you might describe as the being shut down, but actually in terms of whether productivity is being affected. Then you start to look and you combine that number of operatives with the output per operative, and you're starting to get that multiple measure of whether actually productivity, the individuals on site is increasing because there are fewer people on site, but whether that is compensating for some of the loss of workforce. And then finally, you start to get a picture on wider productivity issues. So revenue per worked hour. So that probably ultimately is the most important, because that tells you whether our operatives are going to be able to deliver some of the productivity that is expected on future projects, and preliminaries, again, whether progress is being made sufficiently and whether preliminary costs are increasing. So they're very simple. They start to build a picture of what's going on projects, and most importantly, the team develop these on the basis that information is known to exist on sites. And what we want to be doing is we want to be raising this information from not 1 or 2 projects or dozens of projects, but literally thousands of projects, so the information can be provided to the widest number of contractors, consultants, and clients available. So if we move on to the next slide. And this just summarizes how conceptually the tool is intended to operate. So one of the most important elements about this is it requires a baseline. So if you can imagine, we're going to have a large number of projects which were progressing sort of late last year, and they will have established a baseline of what effective outputs, manning levels and such like might be. And we'll know from that data from, say, for example, September through to February, that forms our baseline. And it's then as you start to sort of move through initially the shutdown and then the recovery period, you start to be able to establish that post-COVID rolling average. And by collecting that information on a monthly basis, you start to bring together a fairly rich picture. So if we go on to the next slide. And this now brings in the estimates adjustment methodology. So again, if we can just go on to the next one. So this here, the principle is if we have any new estimate, now if one thinks about the limitations in terms of data that's currently available, most estimates are going to be prepared on the basis of historic sort of productivity norms, cost planning rates that have been well established in terms of information from previous bids and such like. So it's actually very difficult for people to adjust new cost plans, new estimates to take into account of COVID-related disruption. So what you'll see here is you have your pre-COVID element. You then have certain factors which are adjusted for issues around COVID productivity. There you can see issues around durations, productivity, welfare provision and such like, and of course risk. And then you add a pretended price inflation factor. Now, none of this is rocket science, and it's not intended that it should be sort of substituting the expertise of, say, for example, the estimators and professional cost consultants who are working on these projects. The idea is to do this in a consistent way that gives clients the confidence that these adjustments are being made on the basis of a reasonably large set of data, and that they are being done in a consistent way across a range of projects, so that if one thinks about the overall portfolio that, say, for example, a housing association might have or a public sector client might have, that these things are being dealt with on a consistent and effectively sort of like cross-referable basis. So that's it's very much in terms of intended to be a simple, large-scale approach to enabling people to understand in the aggregate what the risks are, which then enable the sort of like the steps that Helen and David have outlined where they are necessary. Now, if we go on to a summary slide, so I think that's a couple moving on, and I just want to sort of highlight here what the tool is and what it isn't. So again, going back to that overall objective, it's a simple tool to enable people to improve their cost forecasting on the basis of large-scale aggregate data. So there's a strong message there, of course, which is if lots of people aren't using it, then we're not going to make this a progress because we don't have the information. So this is conceptually a bit like the BCIS, only for COVID. Secondly, from the point of view of what it actually is, we'll sort of keep emphasizing this bit, it's an indicative assessment. So it supports decision-making by contracting organizations, by clients, to make the kind of adjustments that otherwise they would need to do effectively blind. Now, it may well be that the information is better for subcontractors rather than main contractors. It's better for PQSs rather than clients. But people who have to make the decisions in terms of how they change their assumptions around COVID, this tool is very much aimed at. That then backs up the second point, that it is for use for everybody. So, and rather than the idea being that this is data that is held by one party, and so therefore that party has slightly better information, and you have a sort of like what you might describe as a slightly a lack of a level playing field. Certainly the way in terms of this is intended to be developed and used by the various parties is that they will have access potentially to all of the information of all of the projects that are involved in. So again, it increases intelligence, gives people a fairly a fair chance in terms of being able to understand what the impacts are. Now, I've highlighted that aggregate data element, and we think that's absolutely essential because I think one of the issues that has affected these initiatives in the past is, of course, that they focus on too much data, and as a result, people don't collect it, and the fundamental power of the principle, which is large-scale data, gets missed out. So it's very much deliberately developed as a aggregate data tool. And then finally, and then going back to that point, this is a support for professional advice. So it's helping people who already understand the principles of contracts, how cost planning works, how estimates work, how risk is managed. It's giving them the additional tools that they need to adjust their advice, not provide what I've described there as a mechanical answer. Now, the what's not is probably more important than the what it is actually. The first one, and it's a very important message for the industry, is we're not asking people to spend a huge amount of time collecting data that they won't need or use. So it's data that already exists that simply needs to be collected in a template. The second one, and probably most importantly for David, and we have had this feedback from one or two clients, is it's not the basis for the claim. It couldn't possibly be the basis for a claim because the data is so, again, so high level, so aggregate, it wouldn't support it. But again, it just gives people better information about what's going on. Secondly, it doesn't provide that assessment of causes and effects that, say, for example, David was describing in terms of those different component parts in terms of the way in which a delay might be managed. And again, it isn't a substitute for professional advice. Now, there you've got a link down at the bottom which takes us to the toolkit if you want to find it on the CLC website. The next steps are to develop a simple database accessible via the cloud, available to everybody at no cost. So that's the next plan. But the initial stage is very much to give people the tools for them to be able to collect their own data. And now I think it is time to go to Q&A. So Omar, if you just want to bring the final slide up.
Fantastic. Thank you, Simon. So yeah, I think it's always in this new world where we're all online, it's very easy to sneak out of webinars. So I think it's a demonstration of how strong this has been, that pretty much everyone who was here at the start is still here at the end. So thanks to our speakers on that. We do have time for some Q&A. If you haven't asked a question, I would encourage you to use the chat function to do so now. But we've had some coming in. So perhaps if we go to the first question, which related to public sector clients. So public sector clients are clearly worried about additional resources from government being slow, so they won't commit. What does the panel consider any enforcing regulations required to cut through this? Perhaps one for maybe Helen and Rob?
Yeah, I'll kick off first, and Helen can tell me I'm wrong. I guess in the experience we've got, so I deal with 2,700 contractors of all sizes throughout the supply chain in the M&E side of the business. Some of them would have really constructive, collaborative conversations using the PPNs and the tools that we've out.
Hello? Have we lost Rob?
Competition law. The reality is, though, we don't know how effective these measures will be, but I will ask Omar to drop into the audience the link to a survey that is currently being undertaken to try and figure out what is required. If further intervention is needed, we need to know the size and the depth of the problem in the industry in order to have those conversations behind the scenes. Certainly, what's there is collateral across the negotiating table. Not sure that Helen has a different view.
Yeah, sorry, Rob, you cut out on a little bit of that, but I think one of the points that you were making is that I think the difficulty for government at the moment is they don't know they don't have the evidence of the full effect of COVID in terms of cost to the industry. And I think that's one of the things that they're looking for, and that hopefully this survey will provide in terms of looking to see whether any further regulations are required, because I don't think they want to do that without having that evidence first.
Excellent. Now, we had a couple of probably not questions, but just points for note. So first is not to forget that Texas was the first with LVD adjudication scheme and is busy. I think we can agree on that one. And also mention of the conflict avoidance pledge. Should clarify that the pledge is the product of the Conflict Avoidance Coalition, which is comprised of RICS, IC, REBA, ICS, ICC, DRBF, SICA, TFL, and Network Rail, to name but a few. So yes, we should recognise that. However, we do have another question. It's a question you get on every webinar. Can we have the slides? The answer is yes. I think we might just need to clear a couple of bits and bobs, but they will be circulated after the meeting. However, another question that could also be asked is touching back on when we talked about what happens if there were to be a second wave, a spike or a mutation. Would force majeure still apply? David, perhaps are you happy to pick that one up?
Yeah, more than happy to, Alistair. There's how many lawyers on this panelist? I think there's myself, Helen, and Rob, isn't there? I think they're all lawyers by background. There might be some more maybe that haven't declared the fact they are lawyers as well. All I would say is you could put the lawyers in a room for a couple of days and ask them whether a new spike is a force majeure, and you would not get a certain answer. Okay, that's a typical lawyer's answer, of course. But my point being is that force majeure, certainly in JCT, is not a defined term. So you need to trawl through old cases to say, well, is it a force majeure? Was it unforeseen? Was it not? Helen would be able to find a load of cases that are different to my cases. Rob could find some different to mine. The point is, as we are now, we can see it on the horizon, can't we? So the simplest answer to it is, I don't know whether it would be a force majeure or not, but I tell you what, there's a simple fix to it, which is to write it down in the contract. It's as simple as that. It's a case of dealing with it in the contract. We are where we are now, and if we can see a second spike coming, is it not on our little list of risks that we think, right, what happens if it does come? So there's a simple solution to it. Rather than lock the lawyers in a room and ask them whether it is or not, just deal with it in the contract going forwards. There you go. So I've sort of avoided giving an answer, Alistair, but I've given a solution. There you go.
I think that's called the lawyer's answer. So excellent. So we're coming close to the end of our time. I don't think we've got any other questions, but we do have the links to the survey. I can only strengthen and encourage what everyone else has already said. Please do fill in that survey. It helps us do the work on your behalf as industry to make the case for any further work that needs to be done in this area. So I'll perhaps leave things on one question that I've got, which just relates perhaps mainly to those on the panel that are lawyers, in terms of what's it actually looking like out there? You know, in your world, how has COVID-19 landed? What are the real world implications in terms of disputes that you're seeing at the moment? Perhaps Helen?
Yeah, sure. Thanks, Alistair. Well, I think at the start, we definitely did see a lot more constructive conversations between clients and contractors. And I think some of those are still ongoing and some of those have led to resolution. But I think now that everyone's back on site, we do see people tending to kick the can down the road and storing up, I suppose, discussing the claim or trying to resolve the claim for later down the line. And that's one of the issues that I tried to highlight in my slide. I think one of the points that Rob made in terms of showing on the timeline when the government support is going to be reduced towards the end of the year, the general feeling is that that's when we'll see the majority of the disputes coming through. So there's always that bit of a lag in terms of when these events happen to when we start seeing the disputes coming through. And whilst I think someone's made the point that the low value dispute adjudication process is busy, I think in general terms people are thinking that it's going to get really busy by the end of the year, because you're going to have the waning of government support and also potentially the waning of the insolvency measures that have been brought in recently that are giving people breathing space as well.
Excellent. And David, well, not excellent, but and David, sort of on the other side of things, how much are you seeing people actually taking on and tackling this in forward-looking contracts? And you've got about 90 seconds.
Yeah, well, I mean, every client I work for, of course, I always will sit down with them and say, you know, glass half empty, what's it going to go wrong? And then they'll give me the first 10 things. So new contracts going forward, we are definitely clearly dealing with it on a project by project basis. Just to touch on the point that Helen mentioned, I have had a project actually where my contractor client stopped work for about 4 weeks and was granted an extension of time for 4 weeks. And in the little side agreement, I wrote in there, so, well, do you accept then that going forwards, COVID-19 is a force majeure? And they went, no, we don't. So we've dealt with it for 4 weeks, but we've kicked the can down the road for the rest of the project. So it's unusual that they accepted the 4 weeks was a ground for time, but they wouldn't come off the fence and accept that any second spike was. So back to the previous question, is a second spike a force majeure? I don't know on that project, because I tried to write it clearly, but couldn't manage to succeed in winning my argument.
Fantastic time, and that is bang on the time. And yes, we've still got the majority of people with us. So on their behalf, because they can't say anything, I would like to thank all of our panelists today who've been outstanding. And we will, as I say, send around further details after the meeting. But thank you as delegates for taking part in the event today, and do give us any feedback that you have after the event. Thank you all and enjoy the rest of your day.